Hello and welcome to our second and final video covering the federal courts, specifically the Supreme Court. Now, when the Supreme Court agrees to take up a case, first they read the briefs that are filed by each side, and then they'll listen to arguments for a few hours. This is their opportunity to ask questions and ask the lawyers from each side to clarify their positions. Then the 9 justices, assuming that the court is full, meet in private and discuss the case. If they all agree, then they issue a unanimous decision. If they disagree, then each side will pick a justice to write an opinion. An opinion isn't just a decision about which side should win the case. It's a detailed explanation of the legal reasoning that the justices use to reach that conclusion. This is important because the opinion that has the most support will now serve as a guide for future court cases. More on that in a bit. As justices write the opinions, they share them with the other justices. The other justices might make suggestions for changes. Sometimes a justice might even change their point of view based on the drafts. There's a lot of discussion, although not hard evidence, that this happened during one of the cases regarding the Affordable Care Act, the Democratic health care law. There's some discussion that the 4 justices who wanted to get rid of the law originally thought that Chief Justice John Roberts was on their side, but then the Chief Justice changed his mind and sided with the 4 justices who wanted to keep the law. Now, because that meant that there were now 5 justices willing to keep the law was ruled constitutional. And because the Chief Justice is considered the most senior justice on the court, the Chief Justice gets to decide who writes the opinion in a group that they agree with. And in this case, Chief Justice Roberts assigned himself to write the opinion in that case. So this idea of back and forth shows that a decision is not final until it is officially entered into the court records. Now, the opinion that has the most support is called the majority opinion, and it's the one that has legal force. The opinion of the smaller group of justices is called the minority or dissenting opinion. And even though they have no legal force, the legal arguments in minority opinions can still be referred to in future cases. Now, if a justice mostly agrees with the minority or majority opinion, but they have a different view of some specific details, they might write what's called a concurring opinion just to lay out those specific arguments. Now, the majority opinion, the decision, is considered a precedent. It's an example that future courts are supposed to follow. Lower courts are required to follow Supreme Court precedents. They cannot rule in a way that contradicts a decision by the Supreme Court. However, a future Supreme Court can overturn a prior Supreme Court decision. For example, that's what Brown versus Board of Education did to the Plessy versus Ferguson decision on whether separate but equal was permissible. Now, while the Supreme Court can overturn a prior decision, many legal theorists consider it important for the law and its interpretation to be fairly stable and predictable, so that people don't have to worry about the Supreme Court swinging wildly from one position to another. And that's why the principle of stare decisis is significant. Stare decisis is another Latin term that basically means the decision stands. So if a Supreme Court decision has been in effect for many years, the idea of stare decisis is that decision should generally be left alone unless there's a really important reason for it to be reconsidered. Maybe technology has changed to make the old decision irrelevant, or there has been a significant change in the way that we perceive the needs of members of society. Now, these days, if you hear senators talking about stare decisis, it's probably because a nominee to the Supreme Court has a different philosophy than they do, and the senators are sort of trying to figure out whether or not the nominee wants to overturn precedents that the senators like, but that the nominee doesn't. For example, if you hear Democratic senators asking a conservative judge about stare decisis, the odds are pretty good that what they're really asking is, would you vote to overturn Roe versus Wade? Or, a decision like that. Now, it takes 5 justices to make a decision, but only 4 to agree to hear a case. As I mentioned before, most of the time the Supreme Court won't take up an appeal of a circuit court decision. But if 2 different circuit courts have come to 2 different decisions, or if the issue at stake is a highly contentious one, the court is more likely to hear the case. Now, the 9 justices have assistants called clerks who help them go through cases and make their decisions about which ones to take on. Clerking for a Supreme Court justice is a very prestigious position for a lawyer, and many clerks have gone on to their own political careers. Now, different judges have different perspectives on the Constitution and how it should be interpreted. One leading philosophy is called originalism, which argues that judges should stick to the original Constitution in making their decisions. This could refer to the original intent of the framers, or it could refer to the exact literal meaning of the words written down in the Constitution. This tends to be a more conservative philosophy that disapproves of the way that the federal government has used things like the elastic clause to expand its reach and influence. According to these theorists, if the Constitution doesn't say anything about the federal government setting up school regulations or healthcare systems or retirement pensions, then the federal government should stay out of that or work on amending the Constitution so that they get the power to do it. Now, there are other theorists who talk about the Constitution as a living document, one whose meaning must be reinterpreted as times change. The framers couldn't conceive of a world with instant global communication, international corporations, militaries that can extinguish all life on the planet. Heck, they didn't even imagine the American political system having parties. So the exact ideas they had aren't precisely applicable to the present day. Instead, we have to figure out how to implement the ideas and the ideals that they enshrine in the Constitution in today's situation. The framers might not have thought specifically about the need for a right to privacy, for example, but in today's world, many people find it essential. So a believer in a living Constitution might be able to interpret the Constitution in a way to support the notion of a right to privacy. This philosophy tends to be adopted more on the liberal or progressive side of the political spectrum because it permits and often even encourages the government to do new things to respond to new problems or to new understandings of old problems. And people on that side of the spectrum tend to favor government taking action to affect society. Now, I just want to wrap up this video by reviewing a couple of key terms whose concepts we've talked about but haven't used the formal term yet. Judicial review is a very significant power of the judicial branch. It's the ability to look at a law or a government action and say, wait a minute, that violates the law or the Constitution. You can't do that, so we're canceling that law or that action. This is part of the checks and balances system that helps put the judicial branch on equal footing with the other 2 branches of government. Finally, we talked about how 4 Supreme Court justices can approve a case for consideration by the court. When they do, they issue a writ of certiorari in order to certify that the case will be heard. If you file an appeal and you don't get your writ of certiorari, you are out of luck. Your case is not being heard. So that will conclude these videos on Chapter 15, as well as these videos on specific chapters in Government America. So thank you very much for watching.